Hi, this is Steve Carlson. I'm still litigating, and as Christmas approaches, the Minnesota Supreme Court is being asked to pay for medical care for women who have been diagnosed with breast cancer under Minnesota's breast cancer treatment program, and when they're thrown off for no valid reason, they should be able to appeal and not to be deprived of that vital care until due process has been allowed, so that there is no possibility of mistake, so that they are being treated as if they are ineligible, when, as the U.S. Supreme Court said in Goldberg versus Kelly, they may be eligible. Petitioners seek this court's discretionary review of the decision of the court below, October 16, 2018, that she is not entitled to continue receiving MABC, Medical Assistance Breast and Cervical Cancer benefits during any further appeal to this court, and that is the Minnesota Court of Appeals. We ask that the Minnesota Supreme Court consider the questions and criteria that are listed here and agree to take the case up and reach a different conclusion, specifically that she has a clear, specific legal right to be paid these benefits and payments by defendants and respondents in this situation infra. We ask that you find no valid excuse for not issuing the writ of mandamus sought, ordering the District Court, Commissioner, and Ramsey County to restore and continue this coverage, using Medicare as the primary payer, pending the disposition of issues surrounding her eligibility for MABC coverage during the remainder of her breast cancer treatment while she is receiving breast cancer treatment. That's the words of the Minnesota statute, while she is receiving. Said treatment is scheduled to end in November 2020 based on the provider's medical decisions, and we are grateful for that treatment. Please note that the briefing schedule below has not yet commenced, and we object to and disagree with the factual assertions and legal arguments of the respondents, including the Commissioner of the Department of Human Services, Emily Piper, and with those stated by the court below, the Court of Appeals. This petition for review concentrates on a single question. Do we show a clear and specific legal duty of any respondent has failed to perform? The Court of Appeals finds we cannot. We answer yes, we can show clear and specific legal duty of all the respondents to follow the law and not deprive her of welfare benefits for cancer treatment, which she might actually be eligible for under the law. Goldberg versus Kelly, the U.S. Supreme Court case, states the state's competing interest in limiting fiscal and administrative burdens is clearly outweighed by the interest in not erroneously treating eligible recipients as ineligible. That's the core interest here, and mitigates against suspending her payments on appeal, even though she's aged in treatment to age 65 and beyond, and not to suspend her benefits irrationally, as has happened here. We believe Congress and the legislature didn't intend her age on starting treatment limit her to partial or lesser treatment. Issues. In light of Minnesota Statutes 256.045 Subdivision 10, which is if the Commissioner of Human Services orders and or services aid or services paid or provided in any proceeding under this section, including subdivisions 3 and 5, it shall be paid or provided pending appeal to the Court of Appeals. By the way, that goes to the Supreme Court as well. For continuing payments and the commands of the U.S. Supreme Court in Goldberg versus Kelly, that is, the subdivision calls for continuing payments, and so does Goldberg versus Kelly. There's a clear, specific right, while appeal is pending in the Court of Appeals under Subdivision 9, identical appeal, not to suspend MABC benefits of women diagnosed with breast cancer under SAGE. Equally clear is that Subdivisions 3 and 5 are both proceedings under this section 256, and the order is triggered by Subdivision 10. Her MABC benefits were suspended and terminated July 2016, 4 months before her 65th birthday. A Minnesota DHS Commissioner Piper included in her favorable decision at that time. The agency erred, that's Ramsey County, should not then have been able to terminate the appellant due to her failure to meet the spend down. They did not provide adequate notice to the appellant concerning this program change. It will need to provide adequate notice now to take her off the breast cancer program and enroll her in the elderly program. By the way, the reason they said she didn't fail to meet the spend down is that she didn't have to pay a spend down. That was the error of Ramsey County. They don't care. The commissioner, speaking through the Attorney General, was right. But then they switched to just proper notice with no chance to appeal or to oppose the termination with adequate notice, advocating the legality of transferring her to the elderly program, supposedly based on no law at all, making her and her spouse spend their income down to 80% of poverty with no discussion. No constitutional consideration allowed. They announced any county can choose to charge cancer patients a spend down illegally, and if they complain, silence them by cutting them off, suspending their MABC payments on appeal with no hearing. It violates the Constitution's 14th Amendment due process clause. The precedent will be followed statewide, recurringly, and critical patients' rights will be destroyed. Denying mandamus, the court constructed invalid excuses, suspending payment on appeal. The court below erroneously found the commissioner's second HSJ as a human services judge, allowing no evidentiary hearing, not making the county provide an appeal summary, that they correctly dismissed an attempted appeal because we impermissibly, supposedly, challenged termination of MABC benefits. And that's our perfect right. Now, supposedly, the presence of this issue extinguished the commissioner's June 8th, 2017 order to pay. It was an order, not a statement, requirement, or mere direction, or merely consistent with the 2017 practices, as the commissioner now says. And it was an order because it was an authoritative directive to pay by the commissioner, the Department of Human Services. So a corollary important statewide recurring question is, can the commissioner order the issue of termination of MABC be raised appealably, giving the human services judge explicit jurisdiction over that question, but who then pretends to eschew jurisdiction, suspending the commissioner's own order to pay on grounds the appellants lost their right to a fair hearing by wrongfully, quote-unquote, appealing and opposing the termination, which we had every reason and right to oppose because the law did not allow us to challenge it under the Equal Protection Act or any constitutional grounds until the case reached the courts, though the commissioner herself said that we could take nothing from the elderly program for her cancer care. Now this violates Minnesota Statutes 256.045 Subdivision 3 State Agency Hearings provision. A, state agency hearings are available, unquote, since the June 15, 2017 order arguably suspended, reduced, terminated, or incorrectly paid. Now, indeed, by refusing to pay and then suspending the benefits on appeal from July 1st to August 30th, 2017, when Kralik supposedly determined the hearing was off for, quote, lack of jurisdiction, unquote, is a 2-month suspension of the ordered payments. And in her response, the commissioner fairly boasts of suspending those payments for 451 days, counting just from July 1st, 2017, and not from July 2016, when she was terminated and all payments were unavailable. Limited interspersed payments made during this period were a bonus, not treated as an entitlement, and subject to overpayment. And further, she avoided treatment. The patient avoided treatment for inability to pay. We ask this court consider this practice as just part of such a departure from the accepted and usual course of justice. This court must supervise this matter and salvage some of Victoria's rights and entitlements, including her right to question whether terminating women randomly based on their treatment and starting age is really what Congress intended, what the legislature intended, and whether doing so would meet constitutional and the Medicaid Act standards. Moreover, by ruling such proceedings under 256.045 subdivision 3 may substitute proper notice for constitutionally adequate notice of termination and program change, they find such misapplication of hearing requirements of the 14th Amendment Due Process Clause to be constitutional, albeit erroneously depriving eligible recipients of MABC benefits, disallowing appeal, barring adequate pre-deprivation notice of precise actions and grounds, denying opportunity to confront state officials, be heard, and object to deprivation. Compare 256.045 subdivision 3. Here payments have been suspended with no due process. According to Commissioner Piper, the legislature refuses to allow consideration of Equal Protection Clause issues and other constitutional questions, even 14th Amendment Due Process Clause issues, while the termination is pending administrative appeal. Here that constitutional vacuum was used to refuse enforcement of that favorable order, to reverse and restore benefits, and to misrepresent the fact and law to the district and appellate courts, all in order to suspend benefits during the time the Goldberg Court said they were most needed. And that need greatly outweighs competing state interests in minimizing fiscal and administrative burdens of paying benefits on appeal. The commissioner is ridiculing a woman who is representative of hundreds of women about Minnesota's ability to deny them medical assistance payments during breast cancer, and especially on appeal, and to deny them the chance to challenge their random terminations through constitutional due process. Obviously, a decision by the Supreme Court will help develop, clarify, or harmonize the law in this important area of cancer treatment and the statutory and constitutional rights of the cancer patients entitled to treatment, so they become no longer mere applicants but eligible recipients with vested rights. See Goldberg. This process is constitutionally flawed, and suspending payments with no hearings or rational reasoning kills the program off for hundreds of affected women in Minnesota. The application of new principle or policy to women screened for breast cancer and deemed entitled to treatment is obviously critical, and suspending payments without rights to contest is critical. The case, as in Goldberg, the state as well as petitioners have competing interests, which revolve around not suspending payments without due process, because it treats eligible recipients as ineligible because they have no rights. In this case, original jurisdiction lay with the Court of Appeals. However, the petition was for a peremptory writ, and with no notice to us, the commissioner filed the very misleading response. She introduced the flawed account that the order she gave, if she even gave it, the court never uses the word order, was limited to just appeals to her. The court also reasoned that there were administrative rules calling for payment when requested by appellants as a matter of course, and that a favorable decision might result in an order not to suspend payments on appeal. But please note that 256.0453 subdivision 3 covers the HSJ hearing process, not just the administrative rules. The law also covers it, and subdivision 5 covers the effect of the Commissioner adopting the HSJ's recommendation, creating a binding final decision that stays final unless appealed, which in this case it was. But nothing says the payment of benefits part is not binding on appeal to the courts. That is a fabrication. And the Commissioner argues, quote, the Commissioner's June 8, 2017 order does not order benefits be paid pending appeal to the District Court and beyond pursuant to 256.045 subdivision 10, unquote. The court below went further, finding, quote, the governing statute and rule, however, provide for continuation of benefits only during the pendency of the appeal to the Commissioner, unquote. The court then goes on to describe the administrative rules for paying benefits on appeal unless, as of 2017 at least, the eligible recipient does not want them. And we want them. But this idea that the order to restore the benefits which had been suspended multiple times was merely some kind of common administrative practice is clearly false. The order clearly rested on wrongful administration by the county. They cut off the benefits without notice, and then were going to cut off the benefits with a spend down as well. So they first cut off the breast cancer benefits, then they were going to cut off all the benefits even if she paid a spend down. And that's what triggered this appeal. The HSJ said she was eligible for MABC and should not have been charged a spend down. So what was the county up to? This was not adequate notice that MABC was to be terminated, or why. The county would not produce written grounds, nor did they put that in the appeal summary. So the HSJ determined there should be clarity as to what was intended and why, and then we needed to have an appeal. The notice should have said, here is why we intend to terminate you and transfer you and your husband to an elderly program, away from the cancer treatment program, during cancer treatment. And we should have had a chance to challenge it. We have got some reasoning out of the Commissioner beginning February 21st, 2018, after years of suspension and evasion. But she got worse. As the attached affidavit shows, she was in the emergency room 3 times in about the last 6 weeks with complications from cancer treatment and inadequate medical care. Now we want to make sure she is cared for while we squarely address the claims of the government that this is the way legislators intended to treat these women. They can die. This is a great responsibility. The case and argument are, outside of death during treatment or completion of treatment prescribed by the provider, 1, should the state end coverage to the patient provided under 256B.057 subdivision 10, certain persons needing treatment for breast or cervical cancer? And if so, 2, how shall it be ended? In terms of the criteria for Supreme Court review, this is an important question, a huge question. It has involved a ruling by the Court of Appeals on the constitutionality of a statute, a finding it is constitutional to deprive her of her needed treatment in the manner used here, refusing, even with celebration, to make payments on appeal of that termination, and negating an order by the MDHS Commissioner made on evidentiary hearing ordering the county agency to make payments. The June 8, 2017 order was not granted because of her age on April 13, 2017, the date of the evidentiary hearing. It was granted because of the way she was treated. She was erroneously treated as ineligible for MABC beginning July 2016 because she was required to pay a spend down, and MABC doesn't have a spend down requirement. And in order to treat her right, the Commissioner ordered Ramsey County caseworker Terrell J. Nelson to pay the patient pending appeal. That is to say, an appeal was still pending, June 8, 2017. Piper didn't say pay benefits until appellants seek judicial review under subdivision 7 or 8 of .045. The mere fact she ordered payments triggered Subdivision 10. And so now clearly and specifically payments must continue to the Supreme Court. It's not discretionary. It doesn't need to be explained to the district court. The issue of forcing women in the breast cancer treatment categorical medical assistance program to go without MABC payments during their treatment under a federal state Medicaid program is a critical issue, especially since so much is at stake for the women and the credibility of the anti-cancer program, and for government control of medical programs as healthcare governance. Okay. I'm sorry if there are any mistakes in this. I stumbled around reading it a little bit, and I will do my best to remedy everything and make everything clear. But in the spirit of Christmas, one thing must be clear, that rather than take the chance that we are treating eligible recipients during their cancer treatment as not eligible for aid, that they have already been found eligible for, and they just need to complete their treatment, why don't we make sure that we allow them to appeal? When we promise we'll pay them, we pay them. We treat them to completion. If there's an overpayment under the law, there are remedies for that. And I want to point out that even if a woman dies in this treatment, and I know that some have, when their treatment was cut off in this way, that the state is hounding them and their families' estates to recover money. They say that they can't give meaningful benefits to women with cancer treatment. They cite U.S. Supreme Court cases that they can take that money and shift it to other people who they place a priority on. Maybe people on welfare, maybe abortion on demand, maybe transgender operations, and all the other things the Minnesota Supreme Court has claimed must be paid under medical assistance, but not for these women. A lot of these things are part of the merits of the case, which we will bring to the Court of Appeals during the briefing session, have already raised in the courts below. I hope that as your holiday gift, you open your ears and your hearts to these women and the families affected by their cancer. Only in this way can we go on to build the war on cancer and to truly protect those with pre-existing conditions, rather than just trying to tell insurance companies what they can and can't sell. Let's fulfill the promises we've made to those with pre-existing conditions like breast cancer. This is Steve Carlson. Happy holidays to you and your family.